Hi. Happy Saturday night. Wait, happy Friday night. It's not Saturday yet. How are you guys doing? Wow, there's already 15 people here. Sorry I'm late. Let's see who's here. Wow, Nancy, Jonathan, Melanie, Mortimer, Tin Man, Richard, Jonathan. I'm trying to scroll really fast. Lisa B. I hope you guys are having a good week, or I hope you had a good week and you're ready for the weekend. Wow. Was I really that late? Y'all are talking a lot. Did I miss anything? Okay, so if some of you haven't been here in a while, I feel like I haven't been here in a while, but I did go ahead and get the computer. You guys are super generous, and I raised about half. So I went ahead and got it, and it's definitely taking some getting used to. I went from a Mac to a PC, from a laptop to a desktop, from something ancient to something super new. It even like lights up right here. It's pretty. I can't find how to open the camera thing to click off the blurriness of the background. It just opens up settings. It's weird. Whatever. I have a lot to learn. Let's just say that. Yeah. It is super shiny. And then like here. Ooh. Okay, that's like the real me. But like there's this option that all of a sudden showed up on StreamYard that says touch up my appearance. Before, after. It's way better, right? But there's like no slider, so you can't like whatever make up on point today. That's the touch up my appearance. Okay, I'll turn it off. It's ridiculous. All right. So I like to warm up, you guys know that. And we're gonna start with some first appearances. Just a couple that are good. Okay, what do? I go to, oh, and one thing I meant to remember, if anybody is playing this back and it's not live, do yourself a favor and just fast forward until you see court, okay? Because there's a lot of technology issues that I have to work through. So just scrub along until you see the court come up, and then you can go ahead and watch. Wait, can you guys hear that? No, because I'm not sharing. Okay. It's been a long time. I feel like I haven't streamed in like a week. Where's the tab that you guys are in? Okay, it's here. And then, okay, minimize that. Present. Share screen. Right here. Share. Okay. And this is Judge Mercer. I believe he's out of the same place as Judge Van. I don't know. I'm going to shut up and play court now.
22nd, Corporal Jones, good morning. Have you had a chance to play the first appearance video, sir?
Good morning. Yes, sir, I have.
Great. Ladies and gentlemen, at the jail, I'm Wade Mercer. I'm the county judge in Jackson County. On your screen, you're going to see you'll see two of us on the screen at least. There are two attorneys involved in the first appearance process. Mr. John McDaniel, assistant public defender, always appears in person at the jail.
Can you guys hear that? Because I can't. Like, I should be hearing it from my headphones, not my microphone. Daylight disinfectant, hello. Check your Discord messages, sir. You're like the only person I know whose preferred method of contact is through YouTube comments. But For real. Okay, wait, where was I going? Dun, dun, dun. Okay, sound. Why isn't the sound? Please work.
Always. He's already at the
Can
jail
you guys
this
hear
morning.
it? I can hear it.
In the
Can you guys hear it? Maybe, maybe not. Thumbs up, thumbs down. Don't mess with me tonight. I'm just gonna play it and you tell me if it's muted.
courtroom, we have the prosecutor, Ms. Bremer. I'm going to ask her to introduce herself.
Kara Bremer on behalf of the state.
Thank you. Can you see and hear both of us at the courthouse, Corporal?
Yes, sir, we can.
Great. We do not have friends or family in the courtroom this morning, so the first case is Andy Miller. Mr. Miller, good morning. Mr. Miller, you're here for first appearance accused of one count of ag assault with a firearm. I
Yes,
read
sir.
the complaint. There is probable cause for the charge. Mr. Miller, when a judge finds probable cause, that does not mean you're guilty. What it means is there's evidence in a sworn under oath complaint that you may have committed the crime you've been accused of, and there's a certain amount of evidence to lead a reasonable person to believe you may be guilty. It does not mean you're guilty. It means there's some evidence that you may have done what you've been accused of. Your criminal history is not bad. You've had nothing since 2018. You had something, and then before that, it was several years before that. So your criminal history is not bad. I'm going to listen to Mr. McDaniel and Ms. Bremer, and then I'm going to address the bond, make a bond or release decision. Mr. McDaniel?
Your Honor, I mean, I read the report. I think you did also. It's, it is what it is. It's, he said it's, I guess, several heat sheets against each other. There was nothing that happened in the case. It sounded like he tried to walk away. Obviously, after they allegedly may have done something he shouldn't have done. I don't know if he did or not, but at this point in time, he lives locally. Been a long time since he's been in trouble. We just asked for some kind of reasonable release.
Ms. Bremer?
Your Honor, the state requests a reasonable bond and no contact with Gabrielle Wiggins or Christopher Lyons.
Now, I've got Ms. Wiggins as an alleged victim. The other person, because he was involved as a witness, is that why you want no contact with him?
He was in the vehicle when the.
And it's interesting because I was wondering how he could be in fear if he stopped the vehicle, got out and approached Mr. Miller. It's hard to argue that he was afraid, but he's not the alleged victim. Ms. Wiggins is. So I appreciate that, Ms. Bremer. I don't know, Mr. McDaniel, I don't know that I'm inclined to grant no contact against him because he's not a victim. I don't see how he could be a victim under these facts. If he stopped the vehicle, got out, and then approached someone carrying a firearm, he obviously wasn't too scared if that's what happened. But Mr. McDaniel, I do want to add, what were you saying, Mr. McDaniel?
Apparently, he also had a knife in his hand as well. So, I mean,
Mr. Miller, I want to ask you a couple of questions. I'm not going to ask you about the incident. That would be inappropriate. But I do need to know about the relationship and where you live. So do you live near Miss Wiggins?
Yes, sir, I do. I've been having
close?
problems.
How close do you live to her?
I'd say within 1,000 yards.
Is it two different driveways or a single driveway?
Miss Wiggins, which Wiggins are you talking
the one
about?
that you got an altercation with yesterday.
Okay. I live here.
How far away?
I'll say at least,
Two different driveways?
yes.
Okay.
Yes. But they come
All
by
right, so two different driveways. Are you related to her or she or her family in
No.
any way? Or just neighbors?
Yes or no?
No.
Okay.
The only thing
That's-
I got
You're
her-
not related, you're not related.
I'm not related, but I got her sister living at my house.
Oh, so.
Yes, and ever since her sister has been living at my house, we've had problems.
that explains
with
a lot.
them.
Okay.
Okay, Mr. McDaniel, it's not your typical ag assault. I know that's your position because that was my position when I read it, but I am concerned about the firearm allegation. What I'm considering is a small cash bond. Mr. McDaniel, have you talked to your client about that possibility?
I talked to him about a bond. Let me.
I think the lawyer just muted the stream because I thought for a minute that I lost volume. I hope that's the case.
No, we'll take a cash bond.
Ms. Bremer, you okay with that?
Yes, Your Honor.
All right, so what I'm gonna do is I'm gonna set you a $500 cash only bond. The good thing about the cash bond, as Mr. McDaniel has probably just explained to you, is if the case is dismissed, it's returned to whoever posted it. Your bond has a condition that you not you have no contact with Gabrielle Wiggins. Ms. Brimmer,
Yes, sir.
is the state requesting no firearm since it's a firearm case?
Yes, Your Honor.
Mr. McDaniel, will you want to be heard on that issue? Gary, who sets the clocks in the courtroom?
God, I love
Who
his.
sets the clocks in the courtroom? When we get a chance.
Love
to
the
somebody
Judge, we don't
else
have any
set that clock. Appreciate it. Mr. Miller, I believe in the person's right to having possessed firearms, but you're accused of a crime with a firearm. So while this case is pending, your bond's going to have a condition that you not have access to firearms. If you have a firearm, when you post bond, take that and give it to a friend, a family member, relative, someone that you don't have access to it. And then when the case is over, you can obviously get that firearm back. So just can't have access to firearms as part of your bond. You'll get to use the phone in just a few minutes, sir, to post the bond and just have no contact with Ms. Wiggins. Do you have any questions, sir?
Yes, sir, I don't.
Have a good day, sir.
Ms. Green.
Ernest Dixon. Mr. Dixon, good morning. You're here for first appearance. Mr. Dixon accused of one count of exposure of sexual organs. Mr. Dixon, there is probable cause for this charge. In the complaint, I'm going to appoint Mr. McDaniel's office to represent you.
No, Tin Man. This is not from Texas. This is from Florida, Jackson County. Who knows where Jackson County is? I feel like it's close to Judge Van. But also, I feel like I want to say that because the room looks similar. But it really doesn't. Somebody knows. Somebody knows. Okay.
Listen to Mr. McDaniel, and he's going to tell me if it's a bond analysis or if it's some type of agreement reached. Mr. McDaniel?
Your Honor, there's going to be a bond analysis.
Shaquille
All right.
O'Neal.
Anything, Mr. McDaniel, on the bond issue before I hear from the state?
Hi.
No, Your Honor. I mean, Mr. Dixon wants to say some things, but I'll let him.
Hey, excuse me, sir.
Yes, sir.
You said it's what did you say when you first came on?
You're
It's probable
accused of one
cause?
count of exposure of sexual organs is what you're accused of, and there is probable cause in the complaint.
Stop it. Is that his name?
Okay,
Is that his name, Mortimer, or are you making a joke? Please tell me. Please tell me that's his name. Please tell me his name is Dickens. Mr. Dixon. Oh my God.
but
This is great.
I wasn't in none of them spots yesterday, and the dude said I pulled my dick out on something. I mean, pull
Yeah, you
whatever. My bad. I'm sorry,
Yeah.
sir.
That's what you're accused of. Yes.
But I thought you got to have some evidence for this. You know what I mean?
There's at least one witness that says you did this. Now that's the evidence that's in the complaint is one person saying they saw you do this. That's what you're accused of.
I could have been pissing on the side of the road or something, but I don't think I would.
Urinating in public is not necessarily a crime, but if you're exposing yourself to someone in the manner that's described in the complaint is a crime, if they can prove that. Did you just get out of jail, Mr. Dixon?
Yes, sir.
Y'all, okay, hold on. Can we just appreciate that one more time? Y'all, hang on. Let's just appreciate it one more time. I didn't turn notifications off. Sorry if it's beeping. Oh, go. Oh no, I went all the way back. Shoot. Sorry, y'all aren't mad, right? I didn't hear that it was Dickens, that it was Mr. Dickens, and I feel like I was looking at technology and I need to focus. Let's go.
Charge in the complaint. I'm going to appoint Mr. McDaniel's office to represent you. Listen to Mr. McDaniel, and he's going to tell me if it's a bond analysis or if it's some type of agreement reached. Mr. McDaniel?
Your Honor, there's going to be a bond analysis.
All right. Anything, Mr. McDaniel, on the bond issue before I hear from the state?
No, Your Honor. I mean, Mr. Dixon wants to say some things, but I'll let him.
Hey, excuse me, sir.
Yes, sir.
You said it's what did you say when you first came on?
You're
probable
accused of one
cause?
count of exposure of sexual organs is what you're accused of, and there is probable cause in the complaint.
Okay, but, I wasn't in none of them spots yesterday, and the dude said I pulled my dick out or something. I mean, pulled
Yeah, you
whatever.
Yeah.
My bad. I'm sorry,
Yeah,
sir.
that's what you're accused of. Yes.
But I thought you got to have some evidence for this. You know what I mean?
There's at least one witness that says you did this. Now that's the evidence that's in the complaint is one person saying they saw you do this. That's what you're accused of.
Oh, sorry, my
I-
face.
I could have been pissing on the side of the road or something, but I don't think I was.
Urinating in public is not necessarily a crime, but if you're exposing yourself to someone in the manner that's described in the complaint is a crime, if they can prove that. Did you just get out of jail, Mr. Dixon?
Yes, sir.
How long has that been since you got out?
About 2 months.
Okay. Mr. Dixon, where do you live at?
I was staying with my mom's, and I was staying with a
Graceville?
friend.
Is that the Graceville
Yes,
area?
God,
Yes,
has that been
sir.
up the whole time?
Let me see if the state has any additional
Comment.
information or input before I address your bond. Ms. Kramer?
Your Honor, the state just requests a reasonable bond.
Mr. Dixon, I'm going to set you a bond of $5,000 cash or surety. The reason your bond is that amount is you just got, let me finish and then I'll answer any questions. The reason your bond is that amount is because you just got out of jail after doing a year sentence. I know you probably did a lot less than a year because you were in the trustee program, I'm assuming, but you did just get out of jail in the last couple of months. Now, don't talk about what you've been accused of. You'll get to use the phone in a few minutes to try to contact friends or family to post the bond. But if you have a question, and if it's a question I can answer, I'll sure try. Any questions?
I ain't got no way to post no bond, so y'all ain't got no offer.
Well, you were made an offer this morning, wasn't he, Mr. McDaniel?
Fair.
Correct.
So what
He
we'll
don't
do is
think,
we'll
he
see.
thinks I made the
Mr.
offer. I mean, I don't know what to say. He thinks I made the offer and it's a bad offer, and I've tried to explain to him I didn't make the offer.
Mr. McDaniel, work on your case and we'll see you at an upcoming docket. In the meantime, if you develop the ability to post bond, you can post bond at any time, okay?
Excuse me, sir. I would have took the offer. But I'm just saying, like, why did I get the max?
Well, you didn't get the max. The maximum for this crime is a year in jail. The offer made to you was basically a year with Public Works, which typically is 6 months. It's the exact same thing you just finished. So you did a
Yes,
year
sir.
and 6 months because you got in the trustee program. So I'm assuming you could get in it again, and you obviously
Yes,
behaved
sir.
yourself at the jail, or you wouldn't have got out so quickly. So it's
Yes, sir.
the equivalent of 6 months if you get in the program like you did last time and stay in it.
Yes, sir. But the last time that I got a charge, it was trespassing after warning. I had
Right.
did it a couple times, but this is my first time for this charge. Why do I get the max? Why are y'all trying to give me the max?
Because you've been out of jail less than 2 months and you're allegedly exposing yourself on the side of a highway by passing by a motorist. Let Mr. McDaniel work on your case, and he'll see if he can get the offer amended in any
Yeah.
way, and we'll see you at an upcoming court date, sir.
Just work on it.
I ain't got time.
Your Honor, he's gonna go ahead. Enter a plea to this, Your Honor. He's gonna enter a plea of no contest to exposure of sexual organs. Your understanding, he'll be sentenced to 11 months, 29 days in county jail with the Public Works option. He'll have 2 days jail credit, be a $370 fine. He'll be adjudicated guilty. He just signed his plea waiver form, waiving his right to jury trial and call witnesses.
Cause y'all
Ms.
wasn't
Kramer's
gonna go down, right? Y'all
Say that
wasn't
last
gonna go
part again?
down. Y'all wasn't gonna go down on the offer, right?
I can't tell you that for sure. Mr. McDaniel may get
Oh,
in your
this is my
case and
first-
he might
Oh,
find some
shit.
information to help you. Or he might get into the case and work on it a couple of months and the offer may stay the same. There's no way I can know that because he'll have private conversations with you and he may find something that convinces the state and myself to lower the offer. But I just don't know. What's hurting you is you just did 1129 and you just got out 2 months ago. That's what's hurting you.
Mm.
So if you want to take this offer today, you can. If you want to wait, that's perfectly okay and see what happens.
Yesterday.
What would you rather do?
He's gonna accept the offer, Your Honor.
Is that what you want to do, Mr. Dixon?
Yeah, yes, sir. Yes, sir.
Ms. Bremer?
It's agreeable with the state, Your Honor.
I'm going to accept your plea of no contest to the charge of exposure of sexual organs, Mr. Dixon. A judge you guilty of that offense, sentence you to 11 months and 29 days in the Jackson County Jail. Credit for 2 days you've served, $370 court costs and fines. And Mr. Dixon, this last part's very important. I do recommend you for the Public Works Trustee Program. You did the program last time, correct?
Yes, sir.
Yeah.
That's what lets you cut it from a year down to about 6 months, which is what you did last time. So you have that opportunity again, and I encourage you to take advantage of that. Mr. Dixon, I do wish you the best, sir.
Mhm.
Have a good day.
Mhm.
Nathaniel Falk.
That guy was great. I mean, he wasn't great. He
I
was
think this is the case, Mr. McDaniel, where
he was definitely not great, but he made me laugh. Because like he could totally just have been peeing on someone, right? Am I muted? I don't think so. This one is short, so we'll just go ahead and let it finish up. I don't think he got a year in prison, did he? I was looking for a file. If you are not an exposed. Oh yeah. If you like watching court at night, please like and subscribe. The lives are not monetized, so liking and subscribing would help. He just got a year? 6 months? Wow. Wow. Oh, okay, 6 months on trustee. Dang. I'm not used to seeing that on like a first appearance. Okay. The next one I have is again on the lighter side. I tried. It's from a little while back. One of my favorite judges.
This is file 2300.
Judge Chisholm in a small claims court. I know I've played him for traffic court before, and he's so grumpy, and I love it. But yeah, y'all. Hi, Grant. Candy came in and chanting everything E&E. Dana. Yeah, so many people here. Okay, oh my gosh, 45 people here. Wow, very cool. Okay, let's watch Judge Chisholm in this small claims. I mean, you're used to seeing him if you watch him with me in traffic, but he's very capable.
0772. Plaintiff is Taylor Casario. Defendant is
Can you guys hear it okay?
Mixon. Prior to beginning the hearing, I want to make sure that you understand that by being in small claims, you're waiving 4 rights. You're waiving the right to be represented by a lawyer. You're waiving the right to try the case to a jury. You're waiving the right to recover more than $6,500. And you're waiving the right to appeal the decision of the judge. Ms. Casario, is it your intention to stay in small claims?
Yes.
Ms. Mixon, is it your intention to stay in small claims?
Yes.
I ask each of you to raise your right hand, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes. Yes.
Thank you. The way we're going to do this, I'm going to ask a series of questions back and forth in no particular order. If I direct a question to you, I'd ask you to answer. If a question is directed to someone else, please let them answer.
Judge Chisholm has very simple rules. If he asks you a question, just answer the question that he asks. Don't try to play with your words. Don't try to maneuver around. He doesn't like it. He won't have it, and he will be done. J-Drink, at this point, I don't think that we know. We don't know who's suing who, but we will find out in just a second.
When I'm done asking the questions that I think I need to ask, I'll then go to the plaintiff. If the plaintiff believes that she needs to add more documents or testimony to the record to complete her case, that would be her opportunity to do so. If she's done, I'll then go to the defendant, and the defendant, if they choose, can add more documents or testimony to complete their defense. In the event that the defendant brings up something new in their portion, the plaintiff would have the chance to respond to that which was brought up new. After that, it's back to me, and I'll issue a judgment. First question I'm going to ask Ms. Mixon is to you. You have been sued for $600. Is there any portion of that sum that you acknowledge you owe?
No,
Ms. Casario, how did you get to the number $600? Why do you think she owes you $600?
That is her monthly payment. That was the last installment of her monthly payment towards me.
Payment for what?
The social media services that she hired me to perform for her.
Was there a contract?
No.
Was there any writing at all?
Yes.
And what kind of a writing do you have?
I have messages back and forth between us that I can provide to you.
It's not a writing. How many months did she pay you $600?
Since June of last year.
When did she stop?
February, this past February.
So June of 2022 was the first payment. And then she paid for the balance of 2022 and for the month of January of 2023.
Yes, and then she discontinued services and I sent her her last invoice and that went unpaid.
Sent her an invoice after she had discontinued services.
Yes, I said, once the remaining balance is taken care of, you will be all set.
When did she discontinue your services?
The invoice was sent February
Ask you that.
14th.
The question I asked you is, when did Ms. Mixon discontinue your services?
Answer the question.
It was on February 14th is when I finalized her services.
I didn't ask you what you did, ma'am. When did she discontinue you?
It was a few days prior to that when we had a conversation.
Ms. Mixon, do you know when you discontinued receiving the services of Ms. Casario?
Aisha Mixon did not have a relationship with Miss Casario. Rich Beauty Company had a relationship with Miss Casario and communicated with Miss Casario.
Rich Beauty. I mean, I think what she's doing here is smart by referring to the business, but
What's the name of the company?
Rich Beauty Company.
Ms. Casario, how did you get paid for the months of June, July through January of 2023? Were you
By
paid
check.
And who drew the check?
The owner of the company.
Was the check you received a company check?
Yes.
sorry.
Why didn't you sue the company?
Isn't she the owner of the company, the president?
How are you going to prove that she owns a company?
She signed the check each month.
Okay, she signed a check on behalf of a company. Was your agreement with her or was it with the company?
It was, my agreement was with her, the owner of the company, and with the company.
Yikes.
Did you receive a 1099 for the monies for the calendar year 2022?
Did I receive a 1099? No, I just deposited those checks into my bank.
I'm talking about the payment of the taxes on that money.
Right.
Did you
I-
report that money as income?
Yes, I did.
Okay, what did you show as the source of the income on your tax return?
The checks that she provided me went into my business banking account. I took that to my accountant. He added everything up. I reported my taxes.
Okay, with $600 for what, 7 months?
Correct.
$4,200. I think anything over 600, you have to have a 1099.
I have my accountant handle all
Okay.
that for me. So
Ms.
if you would like, I
Mixon,
can get with
did
him.
you issue 1099s?
I'm sorry?
I asked Ms. Mixon if he issued 1099s.
You said, is the issue 1099?
No, what I said was, did Rich Beauty, whatever it was, issue 1099s for people that had paid money to?
Rich Beauty Company had an independent contractor.
Is it?
Did you issue that independent contractor?
It was my understanding that she was doing it under the table. That she was,
So
for
you're
the
paying
year
money.
of, for
Did
some
you
companies,
pay
yes, we do.
$600 a business expense?
Hers was personal, so it was just her name. She was just a personal individual who offered.
Did
what she
you,
was offering.
in Rich Beauty Company, did they list the $600 by 7 months or whatever as a business expense?
Oh, yes, under Rich Beauty Company, correct. Yes, it is a business
You
expense.
issue a 1099. Did Rich Beauty Company issue a 1099 to Ms. Casario?
No, Rich Beauty Company did not issue a 1099 to Miss Casario.
Did you personally issue one?
No, definitely not.
But the checks were written payment to Ms. Casario for her services were drawn on the account of the Rich Beauty Company.
That's correct.
Ms. Casario,
Yes,
were the checks that you received all issued by the Rich Beauty Company?
yes.
Sued the wrong person. Sir, you sued the wrong entity. This matter is dismissed.
Okay, so should I now redo
Can't
that
give you
for
legal
Rich Beauty
advice.
Co? I'm
I
sorry?
can't give you legal advice. It's against the law for me to give you
He's so done.
legal advice.
So done. Please. Yes, found it.
So we're all set here today. Thank you.
I mean, if that's not classic Judge Chisholm right there, I don't know what is. He's just the best. He doesn't appreciate nonsense. Okay, now this one, this one is a lot. This was like last week-ish, maybe. Okay, let's see if I can find the beginning. I wrote it on a Post-it note, but I lost the Post-it note. And I actually lost the file. I just found it during that last hearing. It came down to like the last minute. I finally found it. Okay, here we go. Okay, volume's on. What'd you guys think about Judge Chisholm's small claims? I mean, I think that he should do more than more than just traffic, more often. Yeah, that was a nightmare. Yes, he did. This is exactly the vibe that I was getting from him and that I often get from him. He's so fun. Why is this not going?
And interfering
Okay,
to
okay,
your
okay.
It would be with.
Stop. This button works. Y'all. This button works. I can skip 10 seconds. Wow, that's amazing. Skip 10 seconds. Let's just do it. Yeah, he is refreshing, Candy. I think he's great. I mean, he does parking tickets and he makes it good, but I'm just like a weirdo that likes that kind of thing. Wait, it's not skipping anymore. There we go. Right? Oh, it paused. Sorry.
Okay, good morning, everybody. We'll call the case of People versus David William Gratzky, file 23-2172 FY2. It's a date and time of the scheduled plea in the matter. Mr. Gratzky is here by Zoom. Mr. Hunt is here by Zoom. Mr. Chamberlain is here in person for the people. All right, so the original charge, Mr. Gratzky is interfering with an electronic communication device, which I believe is a 5-year felony in domestic violence first, and a 3-day misdemeanor. The plea offer is to plead guilty to attempted interfering with an electronic device.
Are y'all paying attention to these charges? I hope so. I wasn't. We're going back 20 seconds just because I found the button. Sorry.
The original charge, Mr. Gratzky is interfering with an electronic communication device, which I believe is a 5-year felony in domestic violence first, and a 3-day misdemeanor. The plea offer is to plead guilty to attempted interfering with an electronic device, which is a 1-year misdemeanor, and domestic violence first. I think the probable cause statement also says that domestic violence first is with a deferral. Is that correct, Mr. Hunt?
Yes, it is, Your Honor. It would be with the deferred sentencing.
Okay, so it could be, if he's taking a plea, it could get deferred, so that means he might not have to go to jail, right?
All right. All right, so that's the plea offer. Mr. Gratzky, do you understand that plea offer, and do you wish to accept it and plead guilty?
Yes, Your Honor, I do understand it,
So much better than that.
and that will be my plea, yes, sir.
Okay. Okay, so I'm looking in our electronic filing system for the complaint. Yesterday, when I was getting ready for today, I didn't see a complaint, but I think I might see one now. No, I don't have a complaint. So Mr. Chamberlain is going to provide me with a complaint. Thank you.
You're welcome. And interfering is a 2-year, not a 5-year.
Okay, so circuit court would sentence him?
No. You said interfering with an electronic communication.
Oh, is it 2 year?
Is it 2 years?
It's being, okay, pled down to the 1 year. Okay.
Yes, sir.
My mistake. So, Mr. Gratzky, the original charge of interfering with an electronic communication device, that's a 2-year felony instead of a 5. So that was my mistake, but it's being, nonetheless, it's being reduced to a 1-year misdemeanor. Okay.
Okay, so yeah, interfering with dialing 911. I remember a case with a really smug guy from like 90 Day Fiancé. Do you guys remember that? I believe it was on Court TV or something. It was like a year ago, maybe more. But it was kind of a short 2-day trial. But he didn't take the plea and he went to trial, and it was, y'all, that trial was insane. It was nuts. It was short. Maybe we should like watch it in Discord or something at some point. You remember that? Jade. Okay, Jade remembers it. What was his name? God, it was so good. But I remember that specifically. That was, I think, the first time I've really ever heard it explained. But if you prevent someone from calling 911, you know, even if it's just like an argument or whatever, like that's a big deal. Like even just taking their phone and being like, you can't call 911. Like that's bad. Like don't do that. That's a felony. It's bad. Okay, I'm gonna shut up and play because this is so good, guys.
Is it so? No change in the plea offer. All right.
Understood, Your Honor.
Very good. So, sir, are you on any probation or parole at this time?
No, Your Honor.
Okay. Other than this plea offer from the prosecutor, has anything else been promised to you, or have you been forced, threatened, coerced, or had anything done to you to make you plead guilty against your will?
No, Your Honor.
All right, it's your own free choice then to plead guilty, right?
Yes, Your Honor.
Okay. And you've discussed all of your rights to trial then with Mr. Hunt, is that right?
Yes, Your Honor. Mr. Hunt and I haven't spoken.
Okay, and do you understand that by pleading guilty, you're giving up all those trial rights and you won't have a trial? Do you understand that?
Yes, Your Honor.
All right. And if you could not afford Mr. Hunt's services, the court would appoint a lawyer to represent you. Do you understand that?
Yes, Your Honor.
Okay, very good. So the facts of the case are that on or about August 1st of this year, Leelanau County, did this occur at 10120 Southwest Bay Shore Drive, sir?
Yes, Your Honor.
All right, well, the information states that on this date, that location in Leelanau County, that you did willfully and maliciously prevent, obstruct, or delay by any means the conveyance or delivery of an authorized communication by telephone. And then there's also the domestic violence charge. So was this a dispute with what, your spouse?
Yes, Your Honor.
All right. So maybe we should start with the domestic violence. So what happened with regard to the domestic violence charge in terms of committing an assault or an assault battery upon your spouse? What'd you do, sir?
I threw a sandwich. She asked me to go get Subway sandwiches. We're trying to build a house here in Elmwood in Leelanau County. We're having a very difficult time trying to build this house at a reasonable price. We were arguing about money.
Y'all. Y'all. Did you hear that? Were you listening? What is this domestic violence, you ask? Let's use that 10-second button. Y'all are gonna hate that button.
Maybe we should start with the domestic violence. So
Please, let's start.
what happened with regard to the domestic violence charge in terms of committing an assault or an assault battery upon your spouse? What'd you do, sir?
I threw a sandwich. She asked me to go get Subway sandwiches. We're trying to build a house here in Elmwood in Leelanau County. We're having a very difficult time trying to build this house at a reasonable price. We were arguing about money. I was sitting at the dining table and she was sitting on the couch, and we've been bantering back and forth about money, unfortunately. And I threw a sandwich at her. We were in a heavily
Y'all. This is so serious. Like, domestic violence is not funny, but the seriousness with which he says, Your Honor, I threw a sandwich at her.
and we've been bantering back and forth about money, unfortunately. And I threw a sandwich at her. We were in a heavily argument discussion about this.
This is so embarrassing.
Okay. So did the sandwich hit her?
Honestly,
Yes.
I don't remember any of that, sir. I was emotionally upset with the money and everything that was verbally being said that I was not.
Okay, but you intentionally threw the sandwich at your spouse, is that right?
Correct. Yes, Your Honor.
And so it may have hit her, or it may have created the impression in her that she was going to be hit with the sandwich. Are those things correct?
Yes, Your Honor.
All right. It was an intentional act by you, and it's something that your wife did not consent to, is that right?
I agree. Yes, Your Honor.
All right, and it was an act by you that your wife would find to be offensive, is that also correct?
I assume so. Yes, Your Honor.
You weren't acting in self-defense, right?
Correct, Your Honor.
Okay, and then did your wife attempt to make a phone call to get help and you took the phone from her, or what happened?
I don't remember any of that, sir. The only thing I know is she ran out of the house to go to the neighbor's house, and I locked her out of the house to distance myself from her.
And it prevented her from using the telephone, Your Honor. She ended up going to a neighbor's house and using the neighbor's phone to be able to call the police.
All right. Okay. And in terms of throwing up the sandwich, is that the extent of those facts, or?
Just the judge repeats it so many times. The judge says, this is not a mock trial. Dude threw a sandwich at his wife and he locked her out of the house so she couldn't call 911, and he's facing like a 2-year felony for getting in an argument about money when you're building a house and throwing a Subway sandwich at your wife. So people were pissed. The stresses were high. Cops were called. I mean, could this be secretly, horribly abusive household? Maybe. I don't know. You never know what goes on behind closed doors. But like, I look at this guy and I don't, how embarrassing. I don't know. It's ridiculous. I don't think, see, the thing is I don't think he knew at the time. I don't think that they're court experts. I don't think that they watch this stuff. I didn't know that that was even a thing, like that it can be considered kidnapping, right? Like, I don't think, he might not have known it was a thing until the cops got called. They made the report. They asked why she went to a friend's house to call 911 because he locked her out. Like, bing, bam, boom, like kidnapping charge, whatever. Interference with 911, felony. It's crazy.
Please.
All right. Okay. And in terms of throwing up the sandwich, is that the extent of those facts, or is there something more to the assault?
That's to my knowledge, that's the only thing that I remember doing. She was upset, I was upset, and I needed to distance myself from her.
Your Honor, there's a different version in the police report. There's no question about it, but my client disputes that all of those allegations occurred. He does indicate that he knew he was doing something intentionally that would be offensive to her by throwing the sandwich, and obviously didn't provide her with her phone when she left the house.
Right. So, Mr. Chamberlain, do you agree with those facts to accept the plea?
So I just want to confirm that he's saying he knew that he interfered. If he didn't, then a no contest might be appropriate for the interfering with an electronic communication device.
Right. That would be.
I'm sorry, I did not understand that.
Well,
Did you knew her phone was in the house, correct?
Well, yeah, her phones were, she has two phones, a work phone and a personal phone. They had been around her where she was sitting around the couch. Yes,
And
I would know that.
Yeah. And by keeping her out of locking her out of the house, you knew that would prevent her from using those phones to call 911 or any other assistance.
Well, after the fact, yes. At the time and point, I didn't think about it, but yes. If I locked her out of the house and she didn't have her phones with her, then no, she had no means to call anybody. But I knew she was running to the neighbor's house. So looking back on it, yes, I'd have to agree.
Okay, this is where people get in a lot of trouble sometimes, is when they want to accept a plea deal. Like, it's called a plea deal for a reason, because you're getting a better deal. This is going to be on deferred if he manages to plead guilty successfully. So he's not going to have to do jail. He's just going to have to like follow the rules, not have domestic violence with his wife, like live his life like he's been living for the last, I don't know, 65 years. Right? But like, he just needs to say the right thing. I mean, you have to be honest, but like, if he doesn't admit to knowing that what he did was wrong, then sometimes the judge won't take the plea. It kind of sometimes depends on the judge, but let's see. And you know what? They do talk too much, but when it really comes down to admitting what you did wrong, people have a really hard time doing that. And by people, I mean like all of us, right? I mean, it's harder for some than others, but like, it sucks having to say that you were wrong and whatever, mean it.
That's not really the same thing, Your Honor. Your Honor, I can't find his intoxication level. That might be assisting might be of aid to help us figure out if a no contest plea regarding those aspects are appropriate, because Mr. Gratzky said that he doesn't remember quite a bit.
Okay, so actually, I heard that and I meant to ask about that. Was Mr. Gratzky intoxicated at the time, Mr. Hunt?
Your Honor, I believe he had obviously consumed too much alcohol that night. Unfortunately, I do not have a blood alcohol level, but I think he would acknowledge that he knew that he was, I guess, under the influence. He knew he should not leave the residence and drive away because of his intoxication.
Oh, okay. I see what they're going.
I think that's a fair statement, right, Dave?
Yes, that's correct.
All right, so the reason for your lack of recall is due to being intoxicated at the time, sir, is that accurate?
I do not think I was that intoxicated to say that I was drunk to not understand it. Like I said, I was emotionally beat down. It was a very challenging conversation. I was more mentally disturbed than drunk per se.
Your Honor, may I have 5 minutes to check his PBT at the jail? There was no PBT taken on scene, but they would have done a booking, and I'll be back as soon as possible.
Okay, that's fine. So we'll take 5 minutes here so we can check the PBT level.
Okay. Yeah, okay, let me find this. Grapefruits, yeah. I used to get grapefruits in my stocking. I don't know why I liked that so much. Freaking grapefruit. Okay, let's fast forward, fast with this little awesome 10-second button. Oh, are we here? Are we here?
Okay, so this is file 232194 SD2, Ms. Aldridge.
Did I miss it? Y'all, what'd I do? Oh, sorry guys. Y'all knew this wasn't gonna be smooth, right? I lost being able to do the thing with the button.
Gratzky intoxicated at the time, Mr. Hunt?
Forward.
Your Honor, I believe he had obviously consumed too much alcohol that night. Unfortunately, I do
I'm
not
so
have a
sorry.
blood alcohol level, but I think he would acknowledge that he knew that he was, I guess, under the influence. He knew he should not leave the residence and drive away because of his intoxication. I think that's a fair statement, right, Dave?
Yes, that's correct.
I don't think they came back. Why would it let me use the buttons before and not now?
So while we're waiting for Mr. Chamberlain to come back,
Okay,
do you have a plea then, Mr. Resby?
I do, Your Honor. I think they've scanned it in now.
I think so. This is People versus Heather Aldridge, is that right?
That is right, Your Honor.
Okay, so this is file 232194 SD2. Ms. Aldridge is here with Mr. Rasby. There was a pretrial conference this morning. You're charged with operating while intoxicated first, ma'am, a 93-day misdemeanor with driver's license actions from the Secretary of State. Prosecutor's not making any reduced plea offer, so are you here to plead guilty to that original charge?
Yes.
Okay. Are you on any probation or parole?
No.
Okay. Has anything been promised to you, or have you been forced, threatened, coerced, or had anything done to you to make you plead guilty against your will?
No, sir.
Do you want free choice to plead guilty? All right. And you've discussed all of your rights to trial then with Mr. Rasby?
Yep.
Okay, and they're going to take that
It lets me do
about.
it again once it's small.
All right. And when they had contact with you, I sensed that they thought you were intoxicated, so they had you go through sobriety test at the scene. After those, you were arrested, brought to the jail here. We took the data master breath test. Is all that correct?
Yes.
And I don't see the.
0.1617.
Okay, 0.16, 0.17. Do you have any dispute with those results?
1-6.
All right, I'll accept the plea and enter a guilty finding. An assessment has not been done.
Yeah, an assessment has not been done. A pre-sentence report would also be in order.
I'm sorry. I
Okay.
probably should have fast forwarded this.
It's been brought to our attention that there may be a
Yes.
pending bond issue, and we would like to address that with you right now, if we could.
Glad you're here. Hope you come back.
Okay, so, well, the first thing we'll do is refer this to probation for a pre-sentence investigation, sentencing recommendation, substance use assessment. We'll take a look at any bond issue. Oh. So September 13, there was a no bond bench warrant issued. Also, supposed to be 2 days ago for a positive PBT.
So the streams that you guys get aren't always going to be smooth. They're not always going to be perfect, obviously. You guys that are here for the first time, welcome. Thank you for coming. I hope you stay and I hope you come back. I would highly recommend that y'all join the Discord if you haven't already. We have a lot of fun in there. I stream things. I'll stream court cases. We'll talk about everything and nothing. Let me pin this comment so people can find it. If you don't know what you're doing, it's not really too hard. You just make an account. There's a voice chat in there, and you can go in there and you can turn your microphone on and you can talk with everyone, or you can keep yourself muted and just hang out and listen. If and until when you're comfortable, you can talk, or you never have to. Oh my God, this is where I talk too much. Let me just play this court that we're not even really
First
paying attention
gram on
to.
September 12th with a .034 at 6:58 p.m. and an 028
Should work.
at 7:14 p.m. So those are the ideas.
Tuesday, yes, this is the issue we did want to address, Your Honor.
I'm sorry.
Yes, that's the one we've been just recently made aware of.
So how would Ms. Aldridge then be proceeding?
Your Honor, Ms. Aldridge would acknowledge that she's been struggling and did consume alcohol on that afternoon. Her father passed away and is having a difficult time.
That's sad.
She is in the process of reaching out to a counselor. She's also had some issues outside of this with the device itself. She lives near New Directions. She had used a device so that she could travel to work and things like that. She's going to be turning in her device so that you know she will be testing twice daily in person at New Directions from here on out. And we discussed the importance of her making all of those tests and of course testing clean as her sentencing is coming.
Okay, so how soon can you turn your machine in? Oh, it's right there. Okay. All right, so let's do this. What we'll do is have you test now at New Direction. We'll have you turn your machine in. You're on twice daily PBTs set by the magistrate. We'll continue those. So tonight you'll have to test at New Direction, and starting tomorrow morning, that'll be your first morning test. And we'll take no further action, and we'll hope there are no issues on bond going forward before sentencing, okay? All right. And then the sentencing date will be?
That would be October 27th at 9:15.
Oh, shoot.
Sorry, did you say it's one?
27th.
Oh, wow. Okay, that's fine. Thank you.
Okay. Oh, and let's see, could you give Ms. Aldridge probation's phone number?
Yes, Your Honor.
Or actually, do we have those cards now?
No, sir. They're going to be worried as far as I know.
Oh, that would be good.
You know, Jim had an awesome idea this morning, just use cards. So will you give that to Ms.
Yes, of
Aldridge?
course.
All right. All right, you're all set, man.
Thank you, Your Honor.
Thank you.
Okay, please be back.
Oh,
with
that-
the
don't
board.
do that to me.
Where do we turn that in?
I'll admit, I didn't watch this whole thing the first time around. Like the sandwich one. I mean,
Okay.
he threw a sandwich, and that was, I mean, you had me at, Your Honor, I threw the sandwich. Okay. Come on, I don't want to mess it up. I gotta figure out why I can sometimes do this and sometimes not. Doesn't make any sense. Oh, I'm doing it now, I think. 1, 2, 3, 4, 5. Oh, here we go. We're back. What do you guys, okay, what do you guys think? Guess in the chat, and I haven't seen this yet. What do you think his blood alcohol level was? Let's see who wins. I'll give you a minute to guess. So his blood alcohol level. No, there was vinegar on the sub. Yeah, that would be gross. I mean, hopefully it wasn't tuna. Hopefully it wasn't a 0.2, 0.257. All right, I'll give you another minute. I'm going to say 0.16. I think that was for a different case. The classic 1.7. He just used mouthwash. I wasn't drinking, I swear. All right, let's see. You got your votes in. Riveting. But I know if I fast forward it, I'm going to screw it up. Oh, come on. Oh, is that the judge? I wasn't looking at the right screen. No, the judge.
And
sorry.
Tristan, did you find a PBT?
there we go. I was muted and I just did a whole spiel and
I feel
you
ya.
didn't say anything. So what happened is there was no PBT taken, but the CO, the corrections officer, recalls Mr. Gradsky, and he recalls that he did smell heavily of intoxicants, was acting drunk, and they actually had to put him in detox because of alcohol. I think it's probably a little bit of both of being intoxicated and the emotional that he was saying. I think we need to do a no contest plea on this particular aspect because the facts of just locking the door and not letting someone in aren't the same as stopping someone from making a 911 call. So for that, I would allow the no contest on the 1 year, and I guess maybe we'll just do a no contest on all of it because that doesn't make sense to be able to do half and half. I don't know. What are your thoughts?
Well, I mean, that's fine. I guess, there obviously are disputed facts here. And if you watch the body cam, some of the facts don't necessarily support the report, but we can do it for purposes of the plea.
Now, I was actually called on this case by law enforcement.
I know. Yeah.
What?
They were, is that in the report asking whether or not to?
Yeah, whether there was an issue about how they should enter the house.
Okay,
Yeah,
yes.
that was in the body cam.
Oh, okay.
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 All right, please be seated. Okay, so we're unmuted. What did you find out, Mr. Chamberlain?
Your Honor, no PBT was taken, but I talked to the correction officer at the time. He said that he recalls Mr. Gradsky smelling heavily of alcohol.
That was
He felt that
weird. I didn't push any buttons to make it rewind like that, but it did rewind, right? That's so bizarre. Is he saying it all over again? Is it just like now on the record or something? This is Michigan. This is Michigan.
he was drunk, and they did put him in the detox
That's
cell for because of that reason. Your Honor, I would be willing to allow a no contest plea in this case if Mr. Hunt feels that's appropriate, and I've got the report here if you need it.
Okay, Mr. Hunt, how do you feel?
Excuse me. If the court feels that's necessary for the interfering, that's fine, Your Honor, or for either one of them. There are disputed facts in this case about what occurred. All I can tell you is that if you want to use that as your basis for the plea, we can address the rest of the issues that sentencing.
All right. So, okay, Mr. Gratzky, what no contest means, and this is as to the attempted interfering with an electronic device. What no contest means is I'll read the pertinent portions of the police report, which I have while we've been waiting. And if I find a sufficient factual basis to enter a guilty finding to that charge, I will do it without you telling me, I guess, more details than you already have because of your being intoxicated. Is that okay with you?
Well, I think it's both from the alcohol and the emotional distress. I think that Mr.
Sure,
Chamberlain.
okay. For those two reasons, yes. So, Mr. Gratzky, is that acceptable to you, sir?
Yes, Your Honor.
All right, well, okay, I do find a sufficient factual basis to accept that. So I enter a guilty finding to the attempted interference with an electronic communication device, and we'll deal with everything else at sentencing. We'll continue the bond. I'm going to refer the case to probation for a pre-sentence investigation, sentencing recommendations, substance use assessment. As I said, bonds continued. Sentencing then will be
October 27th at 9:30.
That should work. That will be in person in Leelanau County, Your Honor.
yes. And
Okay.
let's see, Mr. Gratzky, I have to give you probation's phone number and have you call them today between 1 and 3 p.m. So can you write this number down?
Yes, Your Honor.
It's 922-6899.
God darn it. Son of a gun. It's okay. It's the end of the stream. Nobody's going to watch it this long anyway. And I generally private them, make it members only for usually the rest of the night, and then I will go ahead and remove the stream. So if you like this kind of thing, and good, I'm glad you didn't hear it. A pre-sentencing report, yeah, it's a for that's what I was saying. Like the interfering with a 911 call, like that's a big deal. That's a 2-year felony. That's a 2-year felony. So, I mean, yeah, it's got to do and there's going to be a whole sentencing and everything because he threw a freaking sandwich at his wife and then locked the door because he was pissed. Like, okay, that's probation's number. That's fine. Okay. But I mean, if you didn't have enough stress in your life already, is that like, you don't have enough money, you're trying to build a house, it's a freaking nightmare out there, and now you've got to pay for a lawyer, because if you're building a house, you don't qualify for the public defender. You've got a felony charge against you. I mean, wow. Something like this can really throw a wrench in your life. But I do have to work tomorrow, early in the morning, all day, and then the next day, and then the next day, and I think I might be off Tuesday and Wednesday. So if we get another stream, I can tell you for sure it's not going to be Sunday night because I'm working overnight. But anyways, I'll keep you guys all posted on Discord about the possibilities when we can go live. But if you haven't joined the Discord, please do. It's a lot of fun. If you like the streams and you have a hard time catching them when they're live or you're late, it only costs like 99 cents to become a member. 99 cents a month. And I spend hours and hours and hours looking for court cases that hopefully you guys haven't already seen. I spend my days in the boring courts. So like I said, I do mark these as members only a few hours after they're done. Generally, I'll leave it there for about a day or the rest of the night, maybe some of the morning, and then I'll go ahead and I'll just take them down. So thank you for being here. Be safe, be kind, follow the law. If you don't follow the law, don't get caught. If you do get caught, please keep your mouth shut. Look out for your friends. Bail them out if you can. And until next time, I'll see you guys in Discord. Bye.